Hello everyone, this is Sachin Sawant, your UK immigration lawyer. I'm live currently. I will take the comments on the channel. Also, if you have any questions, you can type them in the chat. If you have any issues with the setup, you cannot see me, you cannot hear me, please let me know. I will I'm trying to test my chat, create channel to join the chat. Okay. Hello. Okay. Yes, I'm getting the comments. Okay, this live is perfectly functioning well. You can ask me any questions. I will take the comments on the channel. Anyone coming live can ask their questions. There are several many comments on the channel. For the first one I have is from Rashmika. I was under the impression that undefined costs are available under the employers, available with employers. My employer already have them. They only need to allocate it to me. Undefined costs. So the only way your employer may already have it is if at the time of applying for sponsor license, if it's a new license, they asked for the undefined costs, whatever 1, 2, 5, and they gave the reasons and they have the costs on their sponsor management system. That's one way they may have it. Secondly, if they already have the license for a while, for more than a year, in the annual allocations, the sponsor applies for the undefined costs and then home office approves, rejects them. So they may have it as a part of annual allocations or as a part of their sponsor license. If they have not applied or they have used up all their allocations of undefined costs, then they may have zero allocations of undefined costs as of today. They may have to ask for it, apply for it. The standard processing is 18 weeks, priority processing 5 working days, which is very challenging to get. 60, that's what I explained in my previous short in the reply to your previous comment. 60 slots per day for the priority service, very hard to get it. Only if visas are expiring, let's say you're on a student visa, graduate visa, or any visa, and your visas are expiring. I see the live comment, I will come to that. So if the visas are expiring, only then we may be able to expedite it. The lawyers may be able to expedite, but priority service for undefined or rather any priority services for change of circumstances on the sponsor license is quite difficult to get nowadays. Okay, I will take the live question. Please speak out. D-cost delay has been waiting for it since home office is not replying to the email sent. Yeah, with the decost, I know there are many questions. I've tried to reply in every live or every short. There is nothing that home office is doing. I don't know what is the reason. Either they are waiting for the rules to change to 38,700 or whatever the issue is. We don't know anything on the inside. But home office is where they have received a lot of all these DCOS, not just DCOS, even UCOS applications, sponsor license applications, especially defined causes. I know for care worker areas or something. Usually, if it's this is what I've seen. Anytime I'm applying for DCOSs for individuals who have salaries more than 40k or something, 45, 50, 80k, directors, senior levels, we get the approvals very easily. Anytime the salary levels are low, or if you are applying for those care worker, job codes, builders, whichever are in the high risk area where home office is investigating, you will have, I don't know which type of a DCOS, what is the job code that you are applying for, and what are the salaries. If you let me know that, I can maybe elaborate on that as well. But anywhere the salaries are less or close to the border, 26,200, new entrant and all of that, uh, there is a home office is investigating quite very much on that. They are sending questionnaires to the sponsors and all, etc., etc. So it's a pharmacist 2213. So, and what is the salary you are being paid, if you can let me know that. Okay, I'll take the question from Charles. I'm on a tier 2 and I want to change my sponsor to another employer in tier 2 healthcare. Okay, so you're on tier 2. I want to change my sponsor to another employer. Yes, so what is your question, Charles? I understand what you mean. Aditya, sir, I had applied for skilled worker visa on 14 February under priority service with defined costs, finance job. It's been 5 days but haven't received any update. I'm eligible for new entrant. Skilled worker with 14 February with priority service, defined cost, skilled worker priority. We should usually get a response from home office, but I am aware of there are several system issues going on with home office. Sometimes applications are completely lost into that system. I know other lawyers have faced that. I have faced one ILR application for a skilled worker where I filed it about four weeks ago sometime, and the priority service within 5 days they did make a decision, but the decision did not come through. There is a system issue where the decision is not pushed forward. So I'm not sure what is the situation with your case. If you have not received any email from them saying your case is complex, we need more time to decide and all of that, if you have not received that email, then maybe some system issue is blocking it. With lawyers, all the lawyers have their own way of channel of communication with home office to escalate to the seniors, to the management or whatever. We do that, but in your case, see if your employer has a lawyer or legal representative who they engage with, and check with them. That is the only thing that I can say. But other than that, I am aware of that the system issues are there, but usually priority service decisions are made very quickly. I received one priority decision today which was applied day before yesterday, Monday. Yeah, day before yesterday I submitted, and today we got the approval for a skilled worker priority. So I'm not sure, it may be some system issue or something with home office, or maybe some issue with your sponsor or whatever, if they are investigating something. Not sure what exactly the holdup is, but you can call the home office phone line, but I'm pretty sure they are not very helpful. That's just a customer service number. They don't have anything with them. They may just forward your query to the case working, but that is the only recourse you have if you don't have any legal representation or anything like that. So maybe call the customer service number and raise it with them. They may send something to, I know that we never call them, we never use that service, and just let them know that this is what has happened, and see if they are able to send any query or any follow-up email to the caseworker. That's the only thing I can advise, Aditya. So yes, Charles Aaron, if you can ask your question. Other questions I have not got yet, Aditya. Thank you. Yes, KPMG has helped you. Definitely they should follow up with home office. I know your employer may be having KPMG as their legal reps. They should be able, they should follow up on that and see why. If it's five working days, I think that's how they count it. So let the KPMG, your reps know, and they should follow up with the home office. Munawar Pasha, I'm going to pursue Doctor Data Science course, which is part-time at university. Yes, university is not saying full-time students. So my question is that a part-time level can be counted towards long residence. Munawar Pasha, what will be the visa that you are on? That's what I want to know. I understand that the university is not giving a student visa for that particular course. So you are pursuing a Doctor of Data Science course, which is a part-time course, so it will not be sponsorable, which means you cannot get a student visa on that. That's how I understand what you are trying to tell me, which is part-time at university, is not sponsoring full-time students. Is that a part-time level? Okay, can be counted towards long residence. What will be your visa status? I want to know that. If you will not have a student visa, what is the visa that you are, and then you are studying for that part-time course? Okay, by the time I will take some questions, comments that I have on the channel. Okay, so next question is, nursery practitioner are exempt from new skilled worker salary limit because I saw they mentioned that they are going to exempt the new salary limit from care workers as well as education workers. I'm not sure whether, so the question is if nursery practitioners will be exempt from the 38,700 salary limit. I'm not sure if nursery practitioners come under the teachers definition. Education workers, nursery assistants, definitely I don't think so. That is, I think that is more of specific subject teachers, maths, physics, whatever that is, to the best of my knowledge. Still I will check it on the shortage occupation list from where I can find it. Okay, let's find teachers. Teachers. Okay, it is not on this. Maths, physics, physical scientist, physics scientist, nursery. I'm trying to find a nursery assistant job code for you and try to see if I can get an answer on that. To the best of my understanding, I'm pretty sure that's not what they mean. They're not going to exempt nursery practitioners from that 38,700 requirement. But still, I will check. Nursery managers, proprietors, nursery manager. No, not this one. Teaching and other educational professionals not elsewhere classified. Adult education teacher, music teacher, nursery manager. Yeah, so nursery practitioner, nursery assistant are currently not in the shortage occupation, I'm pretty sure, and they will not be exempt from the skilled worker visa from my reading of the rules. I'm looking at the shortage occupation, I'm looking at the occupation codes for skilled worker, all of them together, along with, because mention exempt new salary limit from care workers. Yeah, I don't think when they mean education workers, they don't mean nursery practitioners. I am quite positive on that. Okay, so I don't think that would apply to you. Let me take another question on the channel. Several questions. Thank you, Munawar. Okay. Musify. So I am on PSW visa starting from November 23. Only 3 months gone at the moment with my wife and child as dependents. Part 2 below. Okay, my wife's going to switch to a sponsored care worker visa. Can she get IHS refund if? So the way the IHS works is you get a refund once your new application is approved. So if you want to switch from the PSW to the skilled worker or care worker visa, whoever is switching, you or your wife, whatever is happening. So firstly, you are on PSW and your wife is going to switch. So she is going to switch from dependent of PSW holder. I am on PSW, so she should be. So she is going to switch from dependent of PSW to main skilled worker or care worker. Yeah, so you have to file the application. Usually after 28 days or so, after the approval of the new application, then the IHS is refunded. Sometimes you may have to follow up with them. Worst case scenario, sometimes I've seen up to 90 days or so, they will give the refund. You may have to follow up with them, but 28 days is the usual. They will give a refund after the new application is approved. So you have to pay new IHS, and then later on, once the application is approved, you get the refund of the previous one. So you have to pay at the rate of 1035, which is the current rate, and then get a refund if you paid under the previous one at the rate of 624 per year. So you'll get that one refunded, and that too proportionately. So if your PSW is for 2 years, you've already started, I think you may get a refund of 1 year of IHS. That's how I understand how they calculate it. Yeah, I may be wrong, but yeah, because I don't get into all those things much, but I think you'll get about 1 year of, or 1.5 year on a higher end. I think 1 year only, they don't proportionate the refunds. You'll get a refund of 1 year, I think so. So yes, you will get after the approval. Can myself and our child get IHS refund? Same applies for you and your child as well, because you will change from main PSW to dependent on skilled worker. You will also file a new application. Child is a dependent. Ideal child should also file a new application, because the child is a dependent on you, then the child will become a dependent on your wife. So everyone makes a new application. Ideally, that's how it should be done correctly, and you get the refund after the application is approved. SOL is now immigrant salary list. What major changes are there for the healthcare workers in the list? Yeah, I have. Yeah, I have yet to review that list. Yeah, I cannot comment on that as of now, but I have not done a proper comparison between the list and whatever. But the 38,700 salary will not apply to the health and care workers. That is what I know for sure. That is the only thing I can say about the SOL as of today. Okay, next question. On the channel, my wife didn't receive the marks for dissertation. So she was given a reset on January 25th. Now, end of March, according to CS letter, was finished. So the question is, summary. I will just summarize Atul's question here. Wife did not pass the dissertation, I think so. Then she got a resit on January 25th. Now her result is expected by the end of March. Okay, and according to the CAS, course finished. Course is already finished. Can we apply for care home visa? Because now we are no more dependent on 11th on or after 11th March receiving sponsorship. Yeah, if you receive sponsorship, you can still apply. The course completion, successful course completion is not required. Course completion is required. So if she's failed a dissertation or it is not completed successfully, that is fine for a skilled worker, care worker application. You can file it. Can the date of joining be set to April 1st? Yes, it can be set to April 1st, which would be within 3 months. Yeah, you can set the date of April, start date of work as 1st of April. Application can be submitted before 11th March. Yes, you can submit before 11th March and the start date of work can be 1st of April. And yes, so your wife is the main applicant and you apply before 11th March, you will come under the current care worker rules, dependents allowed. Yes, and you can stay with her in the UK. So you can also apply dependent. You are correct. So all the things are possible for you. Yes, my answer is yes to all of them. Okay. Can you please clarify the clause? Thank you, Joseph. Stay with and bring over in these two fact sheet releases. So far, for one student's visa that has his dependent here in already. Yeah, Joseph, can you please clarify your question? I'm not going to. It is difficult for me to just interpret those 4 words you are writing over there. If you copy and paste whatever you are talking about, or if you tell me the facts of the case, it is much better rather than trying to ask me to interpret the immigration rules on openly. How it applies to you is what matters here. So just tell me the facts of the case and I can tell you what applies, what is possible, what is not. So, Binu Karthikeyan, I am under tier 2 care visa and my wife is international student. Okay, so you are care visa, wife is international student who just started her undergrad course last September. Can I change her visa status to my dependent, to your dependent? A student switching to a dependent, if she drops the course and applies it from India. She drops the course, applies from India. Students, so a student cannot switch if you have not completed the course of study. That is correct. She can do an entry clearance application. That's one. Second part, care worker visa. You are already, yeah, Binil. So since you are already a care worker under the current rules, you can sponsor dependent. Your wife, who she can, yeah, she can drop her course, go back to India, get an entry clearance, and join you. The new changes will not affect her application because you come under the current rules. Whether she applies now or after the change, also she can accompany you. Okay, Russell. Hello. Any other questions I have missed? No. Fine. So, okay, I have answered this one. Anyone coming live, you can ask the questions. See concurrent viewers. I am taking the questions on the channel in comments that I have. I am 45 years old and on graduate route visa. Can I switch to new entrant visa? Yes. So the question is, you are 45 years of age and can you switch to, and you are on graduate route visa. Can I switch to new entrant? Yes, you can switch to new entrant visa. It doesn't stop you. Age is one of the criteria, which is the 26 years. Under 26 years is another criteria. You will qualify the criteria that you are on PSW, You can apply for the skilled worker visa up to 2 years under the new entrant category. So if my application starts, no questions yet. If my application starts 2 weeks before 4th of April, will it fall under the new salary requirement or the older one? UK skilled worker minimum. If my application starts, okay, if that, so I don't know what you mean by if my application starts 2 weeks before 4th April. I think what you're trying to say is the date of application when you submit the application 2 weeks before 4th of April, when the salary increases to 38,700 for the skilled workers, will it fall under the new? It will fall under the old requirement provided you have made a valid application. So the application is valid and the cost is valid, etc., etc. On the salary requirement, he will fall under the old rules. Okay. But what if she has dropped the course? Will it affect her visa? No, dropping the course will not affect her visa. Only switching is not allowed. So that's how the rules of 17 July 2024, if I'm not wrong, that's when the students are stopped from switching to any other visa category if they've not completed their course of study. Switching is inside UK, but entry clearance is perfectly fine. That's based on your human rights. She's your wife, and on that basis, you can sponsor her. Except, yeah, so because you come under the old rules. Yeah. Spouse visa, if anyone 10-year route as a family, as a partner, so partner dad can apply ILR. So the question is about the bereaved spouse ILR. So the bereaved spouse ILR summarily is if you are on a spouse or a partner visa under Appendix FM family route and the sponsor dies, the person who is British citizen, settled person, or pre-settled under the USS, whoever is the sponsor, if that person dies, then the spouse visa or partner visa holder can apply for indefinite leave to remain. Yeah, I've done several of them. It's called as bereaved spouse ILR. So whether you are on 5-year route to settlement or 10-year route to settlement, I don't think it matters. But if it is on the basis of your spouse, yes, you can qualify for bereaved spouse ILR. Okay, next question is live. Can you explain 7-year childhood? Should parents also continue live in the UK? So up to 7 years, can you clarify your question? I don't understand. What do you mean by should parents also continue live in the UK? So do you mean you leave the child over here and go out of the UK? I don't understand. Please clarify that. Then I can explain you in relation to that 7-year child route. Amir sir, please guide about switching visa to care worker visa from PSW after 11th of March. After 11th March, what is happening 11th March? Dependents of care workers. Okay. So can dependents stay with the main applicant when the dependent already in the UK? This guy switching to a care worker visa. So you mean, okay, yeah, this is a question many individuals have. I know I've got it in different formats. So there is a main applicant, PSW visa holder, and you have a partner, say, who is a dependent. You both are in the UK. And your question is, can dependents stay in the UK? So if you switch to the care worker visa, can dependents stay with the main applicant when the dependent already? So Amir, if your question is about if you switch to the care worker visa from PSW, your dependent cannot continue to live in the UK. If your date of application is on or after 11th of March 2024. But if you go to any other skilled worker other than those two job codes 6145 and 6146, care worker and senior care worker, if you are in one of those job codes, then you cannot sponsor your partner. She may have to go back out of the UK because she won't be able to switch. Your partner cannot switch. But if you go to any other job code, yes, your partner can also switch along with you. That is my answer. Yes, sir, I am on a student visa and course due in May. My course due in May. My wife got U course, undefined course. Your student, wife is dependent, awaiting apply for visa. Can I switch to dependent before completing course like in March? No, yeah, so Russell, you cannot switch because you have not completed the course of study. You will have to go outside the UK, make an entry clearance application if that is what you want to do. You cannot switch and become a dependent from inside the UK. If parents outside the UK and come, what is that thing over there? come back to UK. Can parents apply dependent child? Meet Patel, I need all the facts of the case. I don't understand what you mean. The child is left here with some relatives, the parents go outside UK, they come back. I don't understand what you really mean. You have to tell me how long the parents are spending in the UK. Is the child born in the UK? How long the child has spent in the UK? All those facts. Usually you should speak to an immigration lawyer. It really depends on the facts of the case. There are many different facts to the 7-year child route. So proper detailed consultation is required, but still I will need all that information. I don't understand what you mean if parents outside the UK and come back to the UK. So why are parents going outside the UK, leaving the child over here and all of that? So I need all the facts properly. I cannot answer that question unless I have all the facts. Next question on the channel. If my application starts 2 weeks, that one is done. 10-year route. Okay, sole rep. Can a sole representative of his business switch to skilled worker visa? Yes, sole representative visa holders, representative of an overseas business, that is the full name. It's called as sole representative visa commonly. You can switch to a skilled worker before the current visa expires. Yes, you can do a notice period should be served after securing the visa before starting a new job or before applying for skilled worker. Home Office doesn't care about notice periods, that is between you and your employer on the sole rep visa or on skilled worker visa also. Notice period is not a concern for Home Office at all. So you may give the notice, you may leave today, anytime, before the application, after the application. Home Office doesn't expect. What does the Home Office expect? Home Office doesn't expect anything. That's a private contract between you and your employer. It's the employment law side of things. Will there be inquiries for current business of sole representative from the Home Office while switching? Yes, regarding your current sole rep visa, if there is any fraud or any sham thing committed just to allow you entry in the UK and Home Office becomes aware of this, or if there is anything that points them to that, they may investigate that as to why that sole rep was applied previously and now the switching is happening. If there is anything like that, yeah, you should be careful about it. But if everything is clean, I don't think you should worry. It's legally allowed. You can switch from sole rep to skilled worker. There is no issue, no problem with the notice periods. The usual way would be you should apply for this. Is how I would advise: apply for the skilled worker visa, get the visa, then give a notice and leave immediately or with the notice period, whatever that is. Home Office understands change of date, start date of work. That is fine. That can be reported. Okay. Next question, Mukesh Raja. For spouse visa, when are we asked to upload docs? Is it after we pay the application and IHS fees or before that? So after you pay the IHS fees and visa fees, then you are sent to the portal either of VFS or TLS, wherever you are applying. There, that is where you upload all the documents. So how can I contact you directly with premium or fees directly? Yeah, in the channel information, whatever that is called, channel bio or something, there is a website link. You can go and fill up the contact form, and someone will get in touch with you from the office. Yeah, so that's how you should do. You can write the email. The email is also on the website, or fill up the contact form. That's how you contact us. This one is done. Next one is, next question is, I think you already asked that. So Muzifa, I think I've already answered your question live, but anyways, for the purpose of clarity and brevity and of this video, so if anyone else is accessing your comment and trying to find an answer to that, so I'm on a PSW starting from November. So this is the same thing about, can you get IHS refund? You already got a PSW visa, used it for 3 months. You have to make the skilled worker or care worker application. After that, you get a refund, usually within 28 days or so, or after that usually follow up with them. So but the IHS refund is only calculated and refunded after the new application is approved. So remember that. You can get the IHS refund for you and the dependents as well only when their new applications are approved. So that's, it's standard across the board. Main applicant, dependents, whatever, a new application is approved, usually within 28 days or so, they should issue the refund for the previous one, ideally. Okay. No more live questions. I'm taking the questions on the channel. I got EUS status with my old passport, but now I got French passport and I updated my passport details, but I didn't get the letter which was about the passport. Okay, so this the question is about EU settlement scheme, EUSS. Anytime, yeah, this is anytime you get a new identification document. If you get a new passport, you are required to go, it's a digital status, you are required to go and upload a copy of that passport, and that is stored on your record. So you got a new passport and you updated the records, but you didn't get a letter. You don't get any letter, it just gets uploaded onto the system. And when you log in, you will see the new passport details on your digital status. But so you will not get a letter if you are expecting a letter. Can I provide the settled status printout that I got? Yes, the approval letter of the settled status that you got with your previous passport is still valid. That is perfectly fine. You can still submit that at the airport. Basically, they don't even need those settled status letter copies. But yes, I know people do carry those letters to show they have settled status. As soon as you show them your new passport, they put the details of your new passport on the system. They will see your settled status on their system itself. So yes, you won't get any letter for the new passport update. Okay. Why just not refund automatically? What should we need to do? There is, if you Google for IHS refunds UKVI, you should get a website where it gives you some contact information. I think there is an email you write to and you let them know with your application reference and all. And usually they do reply. I know that clients do contact, and that's how you get the refund thing. There is IHS refunds UKVI if you Google for that. Let me just search quickly if I can find it. IHS refunds. Yeah, if you search for IHS refunds, I just searched for the term IHS refunds and it says pay for UK healthcare as part of your application, etc. etc. Okay, can I show my window capture? Let me see. No, I cannot show my window capture. That's fine. Anyways, so that's how you find it. Google for IHS refunds. That website is there. It will tell you how to contact them. Russell, if my wife applied visa in March with UCOS, will I be able to apply in June? Just 1 minute. I have to close my doors. Okay, so the question is, if my wife applied visa in March with UCOS, will I be able to apply in June with the same what salary? Applied visa in March with UCOS, will I be able to apply in June with same salary she's getting now? Salary, you're talking of skilled worker visa. So you are talking of a normal skilled worker visa, not those care home job codes. So yes, if she's already got, I'm talking of other than the care worker job codes here now. So if she applies before the salary increases to 38,700 on 4th of April, she applies in March, then she comes under the current rules, not the 38,700 salary, she can still sponsor you. I'm talking of other job codes, not the care worker job codes here. So that is my answer. If it's a care worker job code, clarify that and I will answer accordingly. Yusuf. So next question is I'm on a student visa with my dependent here in the UK. What happened to my dependent if I cannot change visa by 11th of March because I don't understand the clause? You are on a student visa with your dependent here in the UK. Okay, student plus dependent. What happened to my dependent if cannot change the visa by 11th of March? So I'm assuming you are changing to the care worker job codes. That's what you are applying. So yes, if you don't file the application by 11th of March, a valid application by 11th of March, you will not be able to sponsor your partner. Your partner will have to go back. They cannot continue to live in the UK. That is what the immigration rules mean. Yeah. Okay, thank you. Meet. So next question on the channel, people are already on 3-year skilled worker visa, can't extend with the same employer because they are not CQC regulated. Yes, you are right. So the question is, people who are already on the 3-year skilled worker visa can't extend with the same employer. Yes, they will not be able to extend with the same employer because a new application will have to be filed. Let me think. CQC, I'll write down and think. You cannot extend it because he will not be able to give you a new cost. Yeah, they will not be able to if they change employers. That is the point on CQC. Yeah, because the CQC registered employer, the non-CQC employer will not be able to issue them a new cost for future extensions. They will have to switch to someone who is regulated by the CQC. That's how the rules have been drafted. So yes, you are right. If you are on a 3-year skilled worker visa with a non-CQC employer, then you will have to switch to a CQC employer when your visa ends. Okay. If my care home, next question, Mihir. If my care home willing to provide me the salary threshold level, will I be eligible to bring dependent as a caregiver? Care home willing to provide the salary threshold level. Sorry, I don't understand the question clearly. The dependent being, you being able to sponsor the dependent, I'll answer it in another way. Maybe you can make sense of it. So the ability to sponsor dependents is based on the job code 6145 and 6146. If you are in those job codes, you cannot sponsor dependents after that date, after 11th of March, on or after 11th of March. If you have applied for the care worker job codes visas, then you will not be able to sponsor. It doesn't matter whether what your salaries are, that is not relevant at all. So your question is, if my care home willing to provide me the salary threshold level. So I don't know what is the salary threshold level you are talking of. Will I be eligible to bring dependent as a caregiver? No. If your application is filed on or after 11th of March, my answer is no. If it is filed before 11th of March, then yes. Okay. No live questions. Concurrent viewers. I'm talking about nursery school practitioner UCOS, nursery school practitioner. So what was Russell? My wife applied visa in March with UCOS. Will I be able to apply in June with the same salary? Yes, you can apply. Yeah, Russell, that's fine. So your wife is nursery school practitioner job code. That is not one of those care worker job codes. So then she can sponsor you because she does not come under the 38,700 salary requirement, which will change. So because she will be her date of application, she is already applied, I think. Well, that's what you confirm. Where is your previous? So my wife applied a visa in March. So she's already applied a visa in March. So she will apply a visa in March with you, because yes, you can apply in June and join her, because she can continue to work on that visa. That is fine, that is possible. Okay. Okay, next question is from Suraj Dawn. However, the cost, okay, good information. However, the cost will not be issued until March 11th, as per my understanding. So all those who haven't got the visas yet are on trouble side. Is there any sign of costs will be issued? Yeah, so anyone's DCOSs are pending. They may not be able to make a valid skilled worker application or care worker application before 11th of March, when the rules change for dependents. Yeah, that's what is the hurdle. It will not help. So if the course is not approved, then they are all stuck. You are right, Suraj. So what you're saying is, however, the course will not be issued until March 11th, as per your understanding. So all those who haven't got the visa yet are on the trouble side. Yes, they are on the trouble side. Is there any sign of course being issued? No, no sign of course being issued. They are taking it in the order of receipt. That is the only thing I can say. Okay, so next question I have is, yeah, so Chaturbanka, I've already replied to this question earlier. Joseph, can you please clarify the clause? Okay, this one I have answered. waiting for the cost now for more than 2 months. My care home is regulated by CQC and it's in the tier 2 sponsor list. Any reason why it's delay? Yeah, for the cost issues, delays, I don't have anything to say. Home Office is not responding to any lawyers, representatives that I'm aware of. There is the only thing I know is there is a lot of backlog of decauses. Some are even pending for 6 months and all, especially for these care home jobs and all these job codes. Uh, that is the only thing I can say. Other job codes where the salaries are higher, above 40, 45, 50 and all, those ones, those decauses, we are getting them very quickly. I've got many of them in 2 days also. But there is some prioritization that the Home Office is doing, and they are separating the high risk areas and the low risk ones. They are approving the low risk ones and the high risk ones. And I think many of them which are also not in the care worker area are also stuck in those because of the salaries are very much at the base level, 26,200, new entrant, 30,000 or something like that, just on the lower end of the salary scale, very close to the minimum salary requirements. So your care home CQC regulated, it's in the tier 2 sponsor list, yes. And any reason why it's delay? Yeah, there is no such reason that I can give any reason on that. Uh, they are just trying to investigate every DCOS application from care homes and all. That's what I can say. They are sending all these long queries. I have read several list of queries that have been sent by Home Office. They are asking their current employers who are sponsored, their work rotas, are the visa fees being recovered as a part of salary. They are asking for a copy of the contract, a lot of things. There is a lot of fraud happening in this area, so I think they know that considerable parts, even up to 50% of these care worker job codes and all these issues, Home Office is aware, they are aware of this, and they are investigating every care home on this, every DCOS request rather. That's what I can say. Thanks, Russell. Okay, thank you. And next question on the channel. Please kindly try and answer the questions. Thank you. I don't know which questions. I think I've already answered. Students, so in order to understand. Okay, next question. I'm waiting costs for January. So the cost application, yeah, I think Neetu's question is cost application was filed on 4th January. You are still waiting for the cost approval itself. Forget about this applications, visa application. Can bring my family. Yeah, I don't think you can. The dependence rule applies on the basis of your skilled worker application, the visa application, not the cost application. So the cost application doesn't give you any benefit if it was submitted on 4th of January. UK care workers. Okay, next starting job is 1st of April on cost letter. Can I apply before 11th March? Can I stay with my dependent? Okay. If your start date of job is 1st April and you're submitting the application before 11th March, yes, that is possible. You can submit it on 10th of March, say worst case scenario, or even today, we are in February, March, April. Okay, you can even submit any date from today before till 10th of March, and the start date of work can be 1st of April, and you can still sponsor your dependent. That is possible. No live questions. Okay, rule will be implemented March. What if the person got the cash cost and applied visa before 11 March and there is a list pending in this scenario? Okay, so if a valid application is made, the question of Vidushi is, yes, you got the costs also before 11th of March. The rule will be implemented from 11th of March, not 12th of March, just to clarify, number one. If the person got the costs is approved before, on or before 10th of March, applied for the skilled worker visa on or before 10th of March, and the result is pending, then you should be fine. The date of application of the skilled worker application is what matters. Care worker application, healthcare, whatever you call it, for our purposes it's a skilled worker application. So if that is on or before 10th, then you should be fine. You can sponsor the dependents. Okay, all the questions on the channel I have answered. There are no more live questions, and so I will end this live over here. Thank you very much whoever joined. No more live questions. Okay, one question quickly. Ramzi, hello. I applied for spouse visa. I got it shortly after submission, which is great. But then I got a lucrative job offer. I had to stay with my wife in the UAE. Is my BRP still valid? Do do I pay tax? Yeah, to keep the BRP valid, you don't have to pay any tax. So you applied for the spouse visa. It's your decision if you don't want to continue living in the UK. The BRP, your spouse permission is what I care about. I don't care. The BRP may be valid, that's fine. But if your spouse permission will still be valid, you can enter and exit the UK anytime. Just because you left the UK, so let's say your visa was granted for 33 months, you got the visa, after 10 months you went back to UAE and you started living over there, you should be fine. You still have the remaining period of the visa with you, the spouse visa. So that is fine. Not living in the UK does not end your spouse visa. Not paying taxes in the UK does not end your spouse visa. Hi Rimi. Okay, quickly ask your question. I am waiting. Okay. Yeah, YouTube may stop you from asking questions for some time, maybe 30 seconds, 1 minute. Okay. Okay, I have another question on the channel. What if the occupation code is missing on my course? Occupation code is missing on your course. Sorry, I don't understand. You cannot apply for a course without any occupation code. There has to be an occupation code, whether you apply for an undefined course or you apply for a defined course. You have to tell the home office, the employer has to tell the home office that I'm going to hire this person for this particular job code, whatever that is, 6145, 1234, whatever that is, you have to. So your question is, what if occupation code is missing on the course? It's not possible. Then that's not a valid cause, that's not the correct cause. It may be a fraudulent cause, someone trying to sell you all of those things. Yeah, occupation code should always be there. I don't know what you're looking at, but in the cost details, occupation code is always there. Hemant Kala, I was in PSW, can apply for youth mobility visa. Yeah, if you are under any of the qualifying nations, if you are, let's say, I don't know, you need to tell me, PSW, Youth Mobility Visa is an entry clearance application, nobody can switch. Only if you qualify for the Youth Mobility Visa, you can apply from your home country. You have to go back and apply from there. That's the only thing I can say. Okay, Rimi, what is your question? Where is that? I don't find here. Hi, sir. Gee. Can you copy and paste your question? I will wait. I don't see your question in the live feed. I don't see your question in the comments over here. I will wait for 1 more minute for any questions. Rimi, you can copy and paste your question over here. I will try and answer. Okay. Okay, Ramzi. So if I moved with my British wife to the UK, we are not supposed to pay any taxes on our income in UAE. About the tax matters, you should speak to Home Office. I can only advise on Home Office and visa applications, whether visa is valid or not. To keep your spouse visa valid, there is no requirement to pay taxes, but you should check with a tax advisor or accountant whether you are liable to pay taxes in the UK, depending on how many days you have spent in the UK and all of those things. I cannot advise on tax matters. So how can I get membership? So if you want membership of this channel, then if you click, sorry, I don't know how to get this. If you go in the channel information, there should be some way to get it. Membership, I don't even know. Let me see, how do you go to memberships? If you click on the channel, there should be a membership option in the information or somewhere. Okay, let me check. Where is it? Sorry, I'm trying to find how to find the membership. Okay, so if I go here and Then, yeah, Rimi, I don't see your question. Yeah, I know you are trying to tell me that answer my question, answer my question. I don't see your question on the channel. That's why I'm telling you copy and paste the question over here. Okay. I understand you are saying answering my question, but there is no question on the channel. I don't see it over here. Type the question, please. Yeah, just go in the channel bio page or channel information. You should have the membership options. I think so. That's how, because I cannot find it right now, but maybe I will try to find it out and how to join. But it should be quite easy. If you click on the channel information and all, I'm pretty sure YouTube should allow you, because I know several other people have joined the membership and all. So I don't think it should be that much difficult. Sorry, I may not be able to help on that. Okay, sorry, I have to end this live now. I have not got any more questions now. I don't see your question, Rimi. Can I check validity of my BRP on Savgam portal? Validity of BRP. No, you cannot see validity of the BRP. Your BRP should tell you the validity. It may be up to 31st December 2024. Usually BRPs are expiring then. That's where you see. Or if you want to check your digital status, you can go and do a right to work check and try to generate your share code, put your BRP details, and then it will tell you the permission period. Usually the permission period is also given to you. It is sent by an email, an approval letter, which tells you that you have partner permission under the standard area till this date. So that's how you know the permission period. Or if you don't have any of those documents, you may have to make a subject access request to Home Office and ask for copies of the approval letter from Home Office. So Hemant, I'm currently in UK and I was in PSW. Can I apply for it? Maybe visa Indian scheme? Yes, being on PSW does not stop you from applying for youth mobility visa. If you do qualify, you can still apply from your home country. So being on getting a PSW and spending time on PSW does not preclude you from making a youth mobility application. If you are applying from India, you need that ballot. You should be approved, should be selected in that ballot. If you are selected, you can still apply even if you spend time on PSW. That should be fine. Okay, thank you very much, everyone, and I will end this live now. Thank you.